This is a case that has amazingly now resulted in a criminal conviction against the plaintiff in the case, Shepard Fairey, but that's a different story. The AP was the plaintiff originally. No, the AP wasn't. The AP is the owner of the content. The photo on the left is a photo taken by Manny Garcia. Review: Manny Garcia was a stringer. Does the AP own the copyright in Manny Garcia's photo? You bet your life, because the AP has a stringer agreement. And the stringer agreement says work for hire. And when Manny Garcia tried to get in on this action, the AP said, no, you had an agreement. You signed an agreement. We own the copyright in this photo. Anyway, Manny Garcia shoots this photo of Senator Obama. He's got this very pensive look. It's very contemplative. It's what people thought of Obama. What is he looking at? Does anybody know what he's looking at? George Clooney. George Clooney. They're at a press conference. George Clooney is at the podium. Barack Obama. Yes, that's my wife too. Actually, she doesn't have that pensive look. She has a different look. Anyway, this is the photo that Shepard Fairey uses. How does AP know that Shepard Fairey used the photo? Well, the AP builds encryption into their digital images. And the AP can know down to the second when you used it and what you used. And the reason why Shepard Fairey he's pleaded guilty to criminal contempt of court is because Shepard Fairey lied to the court about. He tried to say it wasn't that AP photo, it was a different photo, and then he did the stupid thing of trying to fabricate evidence to show that it wasn't the photo that AP said it was. Anyway, that's the sideshow. The interesting question from a legal point of view is what Shepard Fairey did fair use? So let's walk through the factors. The first factor is how much. Did he take the whole photo? Yes, he did. Second factor is, what is the nature of the original work? It's a news photo. I'm here to tell you that, unfortunately for you, copyright in facts, in news, is thin. It's weak, because there is no copyright in facts. Why is it that the morning news show on the radio can get away with rewriting your stories?
Yeah, why is that?
Why is that? Why is that? It's because copyright protects the expression of facts. It doesn't protect facts. So when you write the story about how the mayor announced the $2 billion development plan, and the radio says, yesterday, in a new development, there will be a $2 billion plan to develop the marina. I have rewritten the facts. I have not used your words. I've used the facts, but I have not used your expression. So long as I have not used your expression, I'm merely taking the facts. I have not infringed your copyright in your story, or the newspaper's copyright.
The facts came exclusively.
You don't own the facts. So the point is, suppose you've broken a story. You have developed a story. The facts are exclusive to you because you investigated and you found out what the facts are. Point of clarification, you don't own the facts because somebody else knew about what you're reporting. Unless you have developed the formula for some new recipe, it's not new to you. You're merely reciting somebody else's information. But anyway, that's not the point. The point is, facts are not ownable. There is no protection for facts. There is protection for expression.
Well, let me ask this. So if the radio station just took verbatim the story.
So then the alternative is, what if the radio station didn't rewrite the story? What if they just ripped and read? Then, so now they have actually, in some small towns they actually do this. They get the newspaper out and they start reading the newspaper on the air. That's infringement.
Okay.
That's a public performance of your content, and that's one of the protected copyright rights. And so that would be infringing. But again, you own the copyright because you fixed it in tangible medium, but if you don't have a copyright registration, you can't sue them for it because you can't get into court without a copyright registration.
And we actually had that happen with one of our other papers.
Yes.
Local news radio station would basically, on a daily basis, read the stories out of the paper. They would, sometimes they'd give credit, sometimes
Right.
not. And we had to go back and see, well, are you regularly getting a
Copyright registration. Right.
for your rendition?
Or you can say, so there was a scenario with another property where this was happening. The problem was that they didn't have the registration in place. One of the things you can do, you can think about whether you want to do this, is go get a registration for a test for tomorrow, publish it, get a registration, record the radio station doing it, and then come after them for a test case. You can do that, or you can just send them the letter that says, knock it off. And if they have lawyers, they'll say, well, you don't have a copyright registration, but the way this usually gets worked out is we come to an accommodation. We come to some, okay, if you're going to use our stuff, at least give us attribution, give us some credit. The different scenario is on the internet. If you're going to rip us off, take the headline in the first paragraph, we really do want a link back. Whether that link back actually drives any traffic is, I don't know. But
I was going to say, is that how the Huffington Post gets away with it? I mean, as long as they're linking back, I mean, and all the aggregators, I mean, they've literally taken exclusive content
Right.
from me, from
Right.
one of my colleagues,
right.
written by me, and they'll just say the Orange County Register, and I don't
Yeah.
necessarily get that link back.
Again, from the point of view of copyright law, the link back is not dispositive. It's not protective of Huffington Post or any of the other aggregators. What the aggregators are depending upon is you don't have a copyright registration, so you're not going to sue us, and we're only taking the headline in the first paragraph. And
That's the heart of the story.
I know, this is what I say. And they're also making a risk assessment. How likely is it that you're actually going to come after us? And what Huffington Post generally does is if you complain, they'll stop using. But until you complain, they will continue to use. But if you complain, they'll stop. They will say, we drive lots of traffic to you, so it's better for us to use your content. There have been studies. AP is really aggressive around this, and for good reason, because the value of an AP wire story is really in even just the headline, let alone the first paragraph. It's the news. I'm going to get to you. And the AP did a study that looked at how much pass-through was there from aggregators to the original source, and they found that generally the pass-through rate is less than one-third of the hits. Now that's actually could be meaningful, and it's an average. So there's some highs, some lows. There was a case that we handled for a paper where a political website was grabbing. It was grabbing like 5, 6, 7 paragraphs from the paper's political coverage, and they argued that, wow, we're just driving traffic. We're taking your content, we give you a link back, and that newspaper actually did a study of the metrics around the link back. They had 0 pass-throughs. And part of the reason for that is the political, the site that was taking it was taking 5, 6, 7 paragraphs. They were taking the whole story. You don't need to link back when you get the whole story. It might be a little different with a headline and a paragraph, but Huffington Post's business model is we'll take it until you complain. Yeah. Shepard Fairey case was never resolved. Shepard Fairey eventually settled with AP, and there was an exchange of money, but it's confidential. Yes?
Isn't that transformative?
Yes, right. Isn't this transformative? It's for a new purpose. It's not for the news point value. I mean, I think before Shepard Fairey committed criminal contempt, he was probably on his road to winning this case. But you fabricate evidence and you lied to the judge. So this is the last slide. So there's Mike Tyson, and there's his iconic tattoo. And then there's the character from the second, what was the title? It's Hangover, but it's just Hangover 2, is that? Yeah. The tattoo artist who did the tattoo on Mike Tyson's cheek and temple sued Warner Brothers over this. Now, here's an interesting question. First off, does the tattoo artist own the tattoo on Mike Tyson's face? Is it fixed in a tangible medium of expression? Yeah, sort of. But we've never seen a case like this where the tattoo, the only expression of the tattoo is on somebody's body. There have been cases where landscape designers have sued for copyright infringement of their gardens. They come up with a design of a garden. They haven't written down the design of the garden. The garden exists. It is fixed in the sense that it exists. But the courts have said that's not fixation because the garden changes. It grows. The leaves fall off, the leaves grow back, whatever. So the argument was that this was not fixed because it's on Mike Tyson's face, and that's his face. I mean, who knows? But that argument didn't hold any water. The court said, yes, there is copyright owned by the tattoo artist. Then the question is, does Warner Brothers' use of the tattoo, is it transformative?
Yes.
How is it transformative?
It's taking it and making it into a commentary and a satire.
Who is it commenting upon? It's commenting upon Mike Tyson, right. Is Mike Tyson the author? Is Mike Tyson, did Mike Tyson create it?
He had a contract that said it would work for hire.
He might, and actually that was part of the fight, was whether or not there was an agreement between Mike Tyson and the tattoo artist. But the transformative use issue, the question of commentary is complicated by the question of who or what are you commenting upon. It is regularly the case that you take, if you are writing a book review and you take content from the book and you're writing a review about the book, you're commenting upon the content that is the subject of the copyright. That's fair use. That is classic fair use. What if, though, you are taking the content from the book and commenting upon something else? Not the book itself, but you're using the book's content to comment upon some other thing. Suppose, just for giggles, that you take Dr. Seuss, Geisel, his Cat in the Hat book, and his Cat in the Hat rhyme, and you use that for a book about O.J. Simpson and about whether the glove fits. Now you're making a commentary, you're making a critique, you're doing something that's new, but you're not doing about Cat in the Hat or Dr. Seuss. And I don't have that slide up, but that case was found to be not fair. That was, in fact, the Cat Not in the Hat is the name of the book. You can't find it anywhere, not even on eBay. The court ordered that all copies of the book be destroyed. It's a classic example of book burning because the court found that it was not a fair use of Dr. Seuss's copyrighted work. I saw, yes?
As long as we have